The next matter, which is scheduled for 11:30, is Samira Awadallah versus Wells Fargo, or reverse that. Are the counsel for that argument here, both sides? Are you ready to proceed? We're a little early. I mean, if we're waiting on...
9 minutes isn't going to make a difference.
If we're waiting on a client, I'm
No,
willing...
no.
Okay. So, in the proper order, this matter is entitled Wells Fargo Bank versus Samira Awadallah. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you want to let me know when you get started, if you wish to reserve any time, I am keeping the clock this morning. The court has read the briefs, and we are ready to see when you are.
May it please the court, good morning. My name is Michael Lubes. I am the attorney for the appellant, Samira Awadallah, in this case, and I would like to reserve 4 minutes. I think the threshold issue in this case, which is the FHA foreclosure, residential foreclosure issue, is for this court to finally make a determination as to whether or not FHA compliance in a defendant's pleading is a condition precedent or affirmative defense. The court has gone up to that point on several occasions, but never made a definitive ruling. The reason why it's important in this case is because there was never a brief in opposition filed to their motion for summary judgment, and as an affirmative defense, the burden shifts to the defendant to show there's a genuine issue. Without, obviously, a brief in opposition, that's not possible. So if the court were to find this is an affirmative defense, then judgment should be affirmed for Wells Fargo. My argument as to the nature of the defense being condition precedent is the competency of the potential witnesses. If it's an affirmative defense and the borrower has a duty to raise some issue, well, who's competent to testify as to the fact that the notice was sent or not? The loan documents clearly state in Section 8 of the note and 13 of the mortgage that the lender has the obligation to send notice. So the competent party to testify that notice was sent would be the lender. There's no way, the best that the borrower could do is say, I never received notice, but that is irrelevant to the burden of proof in this matter that the notice be sent. So for that reason alone, then there's as the court has opined on several occasions, the districts are all over the place as to some ruling condition precedent, some ruling as affirmative action. I would argue that FHA defense is no different from a notice of acceleration requirement in a Fannie Freddie. It should be a condition precedent because the burden of proof on the issue under the contractual terms is on the lender, the plaintiff in these cases, to demonstrate that the notice itself was sent in accordance with the rules of the note in the mortgage. That being said, condition precedent, Civil Rule 9C refers to a pleading. It doesn't say answer, it just says pleading. Wells Fargo makes a big issue on paragraph 18 of our answer that it was not sufficient and that we didn't raise the issue anywhere in the trial court. First off, as an initial matter, I would argue that paragraph 18 of our answer is sufficient. It is with enough, it's hard to say, specificity and particularity under 9C to shift the burden, if it's a condition precedent, of proof to the plaintiff in this matter. If that's so, our argument today is not only is the 203-604 face-to-face meeting material subject to their burden of proof, but also the 203.602 notice of deficiency notice that's required that we put in our appellate brief. If it's not, our argument is a counterclaim is a pleading. If you look at Civil Rule 7A and 8A, it refers to a counterclaim as a pleading. I would also point out that Civil Rule 8F says that all pleadings shall be construed as to do substantial justice. Obviously, the plaintiff was aware that this was an FHA loan, addressed that on its own accord in the motion for summary judgment in its affidavit. at least as to the 203-604, which was a specific cause of action in the counterclaim. It was the very next page after the end of the answer. It was one document. Count one of our counterclaim, which was the same document that was filed along with the answer, was a claim for breach of contract under 203.604. So if the court were to find that only when you read the answer in conjunction with count one of the counterclaim, then it's our position that at a minimum, they're on the hook for proving compliance with 203.604. So moving to 203.604.
Sometimes all these numbers run together. If you could just quickly
Sure.
tell us basically what the statute or what the
Okay.
number is.
The whole issue here is under 24 CFR 203.606A. The HUD says that all FHA requirements servicing of that subpart have to be complied with. Under
And the ones at issue are?
203.604, the face-to-face meeting,
Right.
and our assertion is 203.602, notice of deficiency.
The timing of the notice of deficiency and the failure to have the face-to-face meeting.
Okay. In 203.602, the notice of deficiency, it's required to be sent to the lenders within 2 months after a missed payment. The face-to-face meeting requirement, both the certified mail requirement as well as the actual attempt to have the face-to-face meeting, is 3 months from a missed payment. Now, I will concede that the certified mail offering made by Wells Fargo seems to comply on its face with the requirement to send the certified mail. However, under 203.604D, it also says that a reasonable effort to conduct the meeting shall include at least one trip to the mortgager's property. And in paramateria with 203.604B, which gives the 3-month requirement, that means that they have to have at least one attempt within 3 months of a missed payment to actually have the face-to-face meeting at the property. That's important because in this case, Wells Fargo relies upon mediation, which occurred during...
There was a notice sent, so 2 certified mail notices sent, correct?
Right, I believe there were other defaults. The most recent one after the last default. I'm going to concede that issue. I'm not going to...
Oh, okay, that's what I wanted to
Exactly.
clarify. All right.
So I believe the certified...
But you're saying that's not enough?
It's not
There
enough.
was no response by your client?
Right, there has to be a reasonable effort. Now, there are some exceptions under 203.606C, the 200 miles, whether they refuse or whatnot. They were never asserted. They tried to show compliance by having this in the middle of the court case, court-sponsored mediation. Okay, there's 3 reasons why that's really not appropriate. First, contractually. Under the terms of the note, it's Section 6, and the mortgage, Section 9, it says that the HUD requirements have to be complied with before acceleration. And obviously, acceleration is a prerequisite to filing the action, because if you don't declare the whole amount due, you can't sue for a sum certain. All right, so contractually, the argument that post-foreclosure filing compliance is possible doesn't make any sense. Second, the regulations themselves clearly state that the meeting has to take place within 3 months of a missed payment. And it has to take place at the person's house, unless they refuse or some other exception applies that they have to assert. This didn't take place at her house. It didn't take place within 3 months of a missed payment.
How could it take place if she didn't answer the letter and communicate back with her?
They would have to make a reasonable effort. They would have to follow up. And normally what happens in these cases is in their call notes, they say that someone came to the house or something like that, and the person called back on the phone and said, you know, don't even bother or something. There would be a refusal. But there has to be the follow-on attempt. The regulation, if you look at 203.604D, is very clear in the language of the regulation. It shall also include an effort to meet the person on top of the certified mail letter. Okay. So obviously, in-court mediation only took place in the court, not at the property, didn't take place within 3 months, and it was during mediation. That brings me to my third point. Mediation isn't supposed to be an evidentiary procedure. If we're going to rely on mediation to prove an element of someone's case, then a whole Pandora's box opens up. We do discovery on that. They say that the assertion here is that she didn't comply. She didn't get a full application. Well, that's an issue of fact. We should be able to issue discovery on that. Well, why? We sent you a bunch of stuff. We think we sent everything we were supposed to have a complete application. How is that possible? Obviously, mediation isn't set up for that. So for those 3 reasons, contractual, regulatory, and just the civil procedure, that the whole idea that in court, mediation can somehow satisfy that requirement to attempt face-to-face meeting doesn't work. Now, I know there's the federal regulation that they cite where HUD says that might actually work. That's fine between whether HUD comes down on them or not. That's their issue. All right? We don't plead their failure to report to HUD or anything like that. We're only pleading issues that affect the borrowers directly. All right? So if HUD says, we're not going to ding you, Wells Fargo, if you have in-court mediation, that's fine if that's the position HUD wants to take as far as their regulatory oversight position, but it doesn't have anything to do with the terms of the contract or the regulation or civil proceedings as they happen in Ohio or anywhere else in the country.
You have just over 4 minutes remaining.
I think that the hard, I'll reserve the rest of whatever I say for rebuttal.
Good morning. May it please the court, my name is Jeremy Smith and I'm here on behalf of Wells Fargo. Ms. Awadallah argues that Wells Fargo's evidence is insufficient to entitle it to summary judgment because it did not prove compliance with 203-604, the face-to-face regulation, or 203-602, the notice regulation. The first problem with those arguments is they were not raised to the trial court. Ms. Awadallah did not present non-compliance with any HUD regulation as a defense to Wells Fargo's claims under the complaint. It's true, as Mr. Lubes noted, that the face-to-face regulation was the subject of the counterclaim, but it was raised affirmatively. It was not raised defensively. It was not raised in the answer. It was not raised in opposition to Wells Fargo's motion for summary judgment. And Ms. Awadallah did file a Civil Rule 60B motion for relief in which she chose to argue the application of a different HUD regulation, 20150, which is a notice regulation applicable to manufactured homes. This was just never brought to the trial court as a defense. The parties did not argue it as such, and the court did not consider that defense. Having failed to make any argument to the court that non-compliance with those regulations is a defense, it's Wells Fargo's position that they're waived on appeal. In any event, Mr. Lubes suggests that the court should consider whether these regulations are an affirmative defense or a conditioned proceeding. It's Wells Fargo's position that although the courts in Ohio are split on the issue, that determination is not really necessary here. Wells Fargo, it's its position that they're an affirmative defense. As Mr. Lubes has conceded, because there's no opposition to Wells Fargo's motion for summary judgment, no evidence on the issue of the regulations was submitted by Ms. Awadallah. If it is an affirmative defense, the court should affirm the judgment of the trial court. If, on the other hand, the regulations are a conditioned proceeding, it's Wells Fargo's position that Ms. Awadallah has waived compliance with those regulations by failing to deny them with particularity. Wells Fargo generally averred that it complied with all conditions proceeding prior to bringing this case. Ms. Awadallah generally denied that allegation. Ms. Awadallah relies on the statement and the answer, which states, Wells Fargo did not provide required notices under the note and mortgage. That's simply not a specific denial. There are 5 total notices mentioned between the note and the mortgage, and that statement in the answer does not state which notices Wells Fargo was required to send or which notices it failed to send. Second, Ms. Awadallah argues that the counterclaim counts as a specific denial. It's Wells Fargo's position that Civil Rule 8 requires denials to be made in response to pleadings. It's Wells Fargo's position that that requires it to be in a responsive pleading, not an affirmative claim for relief. Now, Wells Fargo is aware that this court has refused to consider admissions in the pleadings when the plaintiff did not make reference to those admissions in its motion for summary judgment. With respect, Wells Fargo requests that this court reconsider that reasoning. The Supreme Court of Ohio and this court has held that admissions in pleadings are equivalent to proof of the fact. If compliance is admitted, It's admitted as between the parties regardless of whether or not the plaintiff mentions it in its motion for summary judgment. Relatedly, this court conducts an independent de novo review of the record to determine if summary judgment is appropriate. The pleadings and the admissions therein are part of that record, again, whether or not the plaintiff mentions them in its motion for summary judgment. Regardless of how the regulations are classified, it's Wells Fargo's position that it complied with those regulations. First, as required by 602, the notice regulation, it sent notice of default within 2 months. That notice contained the amount due, the reason for the default, the date on which the amount must be paid to avoid acceleration. It also contained a telephone number for Wells Fargo and a number for independent foreclosure prevention agencies. To the extent Wells Fargo's notice does not comply with the precise letter of HUD policy, Wells Fargo submits that any omissions were technical and there is no evidence that any of those omissions would have had any effect on the outcome of this case. Ms. Awadallah still had the information necessary to cure, contact information for Wells Fargo, and contact information for foreclosure prevention agencies. In regards to the face-to-face regulation, section 604, Wells Fargo requested a face-to-face meeting through certified mail. It also participated in court-sponsored mediation, but the parties were unable to come to a resolution. The purpose of this regulation, as other courts have stated, is to ensure that the parties have an opportunity to discuss foreclosure alternatives. Here, it's undisputed that they did. Wells Fargo sent a certified letter requesting that Ms. Awadallah schedule a face-to-face meeting. It's unclear whether that ever took place. Wells Fargo.
Excuse me for interrupting. The face-to-face meeting is supposed to take place at the house, or can it take place anywhere?
The regulation requires a face-to-face meeting to take place. It also says that the lender must, a face-to-face meeting must take place, or the lender must make a reasonable effort to have a face-to-face meeting.
But does it require the location be at the house?
In the section of the regulation that describes what a reasonable effort would be, it says a reasonable effort consists of, as Mr. Lewis pointed out, a certified letter, a visit to the property, but it does not say exactly where it has to take place, but it does say that the lender must take a visit to the property. And Wells Fargo concedes that there's nothing in the record that states whether that took place. But it's Wells Fargo's position that, as other courts have held, mediation and court-sponsored mediation satisfies the regulation because the purpose of the regulation is to ensure that the parties discuss foreclosure alternatives, and in that case, they would have. Here, in this case, not only did Wells Fargo participate in court-sponsored mediation, but it's also undisputed that it requested a face-to-face meeting through certified mail. It's Wells Fargo's position that that's substantial compliance with the regulation, and it's met the purpose of the regulation. Ms. Awadallah has suggested that Wells Fargo's participation in court-sponsored mediation essentially should not count because it came after the complaint. It's Wells Fargo's position that HUD's own interpretation of its regulation, which states that if a lender has a duty to perform a loss mitigation review but does not perform that review prior to filing the complaint, it can avoid a penalty from HUD by staying the foreclosure action, conducting the loss mitigation review, and then continuing on if necessary. It's Wells Fargo's position that these regulations were drafted for the benefit of HUD. They're intended to govern the relationship between the lender and HUD, and if HUD says that that satisfies the regulation, that should be held to satisfy the regulation. Finally, Ms. Awadallah raises some evidentiary objections to the testimony of Alicia Mulder, Wells Fargo's witness at the summary judgment stage. Specifically, she argues that Ms. Mulder's testimony does not meet the business record exception to hearsay because mediation is not a regularly conducted business activity. First, this argument was waived because it was not made to the trial court. Second, this affidavit testifies that Ms. Mulder had personal knowledge of all information therein after reviewing Wells Fargo's regularly maintained business records that it keeps in the ordinary course of business. In the absence of any evidence to the contrary, it's Wells Fargo's position that that meets the requirements of Evidence Rule 803-6. And in any event, the fact that mediation occurred is reflected on the trial court's docket. Finally, in response to Ms. Awadallah's argument that mediation should not be considered in reviewing the merits of the claim, Wells Fargo is not seeking to take any certain statement from mediation and use that as evidence, contrary to the Ohio rules of evidence. It's simply demonstrating the fact that mediation occurred, which again is referenced on the court's docket. The fact that it occurred demonstrates that the parties had a chance to discuss foreclosure alternatives. For these reasons, Wells Fargo respectfully requests that the court affirm the judgment of the trial court and overrule the assignments of error. Thank you.
just going to read 203.604D, word for word. A reasonable effort to arrange a face-to-face meeting with the mortgager shall consist at a minimum of one letter sent to the mortgager certified by the Postal Service as having been dispatched. Such a reasonable effort to arrange a face-to-face meeting shall also include at least one trip to see the mortgager at the mortgaged property, unless the mortgaged property is more than 200 miles from the mortgagee, its servicer, or a branch office, or either, or it is known that the mortgagor is not residing in the mortgaged property. That's what it says. At the mortgaged property, not at court, not 2 years later after she's been served with a complaint and sued. The note in the mortgage say what the note in the mortgage say. It has to be done prior to acceleration. Again, if HUD doesn't want to penalize Wells Fargo, if Wells Fargo has mediation, that's fine for HUD. It's not Awadallah's issue, is HUD compliance as far as HUD's ability to oversee and regulate lenders under their program. It's a contractual provision. They are contractually obligated to comply with these regulations. We talk about specificity and particularity under 18, in paragraph 18. And he weighs off the issue of, the counterclaims, affirmative defense, or whatever to justify not including the breach of contract counterclaim. I'm just going to read the last sentence of Civil Rule 9C. A denial of performance or occurrence shall be made specifically and with particularity. It doesn't say as a counterclaim, or an affirmative defense, or a sword, or a shield. It just says you have to make it. And clearly we made it. We made it in multiple paragraphs in count 1 of counterclaim. Specifically and with particularity. He talks about the purpose of the regulation to ensure parties discuss foreclosure alternatives and seem to waive off the time requirements. As the court's aware, time is money in foreclosure. Every month where there's a missed payment, those payments have to be made up in any kind of loss mitigation. If you wait 2 years to have this face-to-face meeting, it makes it much more problematic that the person can do some kind of home retention option where all that missed payments are recapitalized into new principal and the monthly payments go way higher than their original monthly payment. The reason why HUD puts these time limits in these requirements is to get an act to be performed that gives the borrowers the best chance to retain the home before all this time lapses. The terms of the note and mortgage allow for court costs and attorney's fees to be added to the balance of the loan. That's more money that in mediation after a complaint is filed, it will be piled into new principal for a loan modification. Clearly, HUD, in putting these contractual obligations that it has to be done pre-acceleration, wants this done before all the extra payments and all the extra court costs and attorney's fees are added into the balance of the loan. This has to be done within 3 months. It's not just a substantial compliance issue. And finally, as a business record exception, he mentions that we waived it. Under Bowie, which we cite in our brief for another issue, on paragraph 13, and that's 2014 Ohio 1208, it was put up just about a year ago by this court. Chapter 13 says if they don't mention it in their MSJ, they waive the waiver argument. They never mention any of this waiving in their MSJ. So no matter what we missed our brief in opposition or our 60B motion, cited the wrong things, and I agree we cited the wrong issue. My preceding attorney of record used the mobile home defense. It's irrelevant to this case. It's their case in chief. It's a condition precedent. They have to meet this burden in the motion for summary judgment. There is not a nickel's worth of thing we have to do if they don't meet that initial burden of proof under 56. We don't have to file a brief in opposition. We don't have to point out that they don't meet the burden of proof. They have to make their burden of proof. And they failed to do that. They failed, I believe, under 602. They can say they sent a demand letter, but they didn't say that it complied with 203.602. But if the court says that we have to get the specific amount of particularity and specificity under 9C to include the counterclaim, then we're stuck with 604. But still, this court-sponsored mediation can never count for that requirement. They have a face-to-face meeting with the mortgager at the mortgage property within 3 months of a missed payment.
And counsel, you have reached the end of your allotted time today. Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which we know on both sides as well as posted on our website and on